Hello everyone and welcome to 2TG's Employment Law webinar. My name is Emma Walker, I'm a barrister at 2 Temple Gardens, and I'm going to be covering today 2022, looking at a year in review of some of the key employment developments that occurred over 2022 and of course are going to have an impact on 2023. So we can't talk about 2022 without of course still looking at the issue of COVID. Now, I'm sure as you all remember, as of the 21st of February 2022, the government announced that most of the remaining rules in place would come to an end. And as of course, now, January 2023, this situation has not changed, despite at the moment there is unfortunately growing numbers of individuals who are currently again suffering from COVID. But what this did mean back in February 2022 is that the legal requirement to self-isolate was removed as of 24th of January 2022, and adults who tested positive would be advised to stay at home for at least 4 or 5 days and continue to do so until testing negative twice. However, employees were not under a legal duty to notify their employers that they had the virus. And this, of course, was in line with the fact that the lockdowns as of February 2022 changed. Employers did, however, and still do have a common law duty to take reasonable steps to prevent harm to employees. In addition, we saw in March of 2022 changes to the statutory sick pay regime. And as of 17th of March 2022, the statutory sick pay rebate scheme closed, and employers were not able to claim back SSP for COVID-19 related absences or self-isolation that occurred after 17th of March 2022. And there were various different dates that employers had to meet, including that until 24th of March 2022, that new claims were submitted for absence appearances up to and including the 17th of March, or to amend any claims that they'd already submitted. And then from 24th of March 2022, COVID-19 provisions in respect of SSP ended entirely. What we did see is, luckily, as of the 6th of April 2022, the SSP rose by 3.11%, and the new rate was £99.35, up from £96.35. And that, of course, is still in place today. And then from the 1st of July 2022, fit notes could be certified and issued by nurses, occupational therapists, pharmacists, and physiotherapists. This was in addition to the requirement that it needed to be provided by a doctor. As we're all aware, the current situation in relation to individuals obtaining doctors' medical appointments, it is very hard for people to see their GP, and therefore the expansion of those that could certify has, of course, allowed both the ability for individuals to obtain a fit note, but also hopefully reducing a slight element of additional pressure that GPs are currently facing at this time. In my previous webinar back in April, I addressed the case of Rogers and Leeds Laser Cutting Limited 2022 EWCA CIV 1659. Now, in that time, since having addressed the matter, there have been some developments. And in fact, since March and April, it's gone all the way to the Court of Appeal. Now, I'm sure you all remember this matter because it addressed the interplay between Section 100 of the RA 1996 and COVID-19. Now, Mr. Rogers was unfortunately unsuccessful, both at the first tier. He then appealed. He was unsuccessful again. And then he took it all the way to Court of Appeal. And this is the first case that we've seen reach the Court of Appeal to deal with this interplay. Now, of particular note in relation to Mr. Rogers' unsuccessful appeal, the Court of Appeal has provided guidance on the correct interpretation of Section 100, subsection 1, subsection D. And it began by making the point that whilst Section 100, subsection 1, subsection D refers to, quote unquote, circumstances of danger, there need not objectively be a danger. A reasonable but erroneous belief on the part of the employee is in fact enough, and the danger must arise at the workplace. If that is not the case, the question of an employee leaving would not arise. However, it does not follow that it can only arise at the workplace. And the Court of Appeal has said that the questions that need to be decided in relation to Section 100, subsection 1, subsection D claim are as follows. Did the employee believe that there were circumstances of serious and imminent danger at the workplace? And if so, was that belief reasonable? And if so, could they reasonably have averted that danger? If not, did they leave or propose to leave or refuse to return to the workplace or the relevant part because of the perceived serious and imminent danger? If so, was that reason or principal reason for their dismissal? So it's been helpful now that we've had this clarification because, of course, there were a number of cases that we saw, as was addressed in my previous webinar, that covered the issue about workplace, the feeling and perceived feeling of danger when in the workplace, and whether you have the right to refuse to attend the workplace due to said danger. Now, of course, this is the Court of Appeal that's come to this conclusion. There doesn't seem to be any hint that this might be getting appealed to the Supreme Court, but of course, it might mean that we see more cases that interpret the questions to be decided at the first tier tribunal. Another key case that came out of 2022 was the matter of Smith and Pimlico Plumbers Limited, 2022 EWCA CIV 70, and this dealt with annual leave for quote-unquote gig workers. In this matter, importantly, the Court of Appeal decided that workers who had taken annual leave but who had not been paid for it as they were treated as self-employed were in fact entitled to claim holiday pay going back through the entire period of their employment. So this was a significant win for those individuals who are gig workers and had not received the benefit of holiday pay during their period of being self-employed. And the claimant won his claim that he was a worker that fell within the meaning of Section 230, subsection 3, the RA 96, and Regulation 2, subsection 1 of the Working Time Regulations 98, which meant he was therefore entitled to paid leave. Another case that dealt with the issue of holiday pay was the matter of Harper Trust and Brazel 2022 UKSC 21, and this was the Supreme Court looking at the interpretation of what holiday pay calculations are. Now, in this case, the Supreme Court clarified the law on calculation of holiday pay for the part-year workers. So these are individuals, as was the case of Ms. Brazel, who was a teacher, a music teacher specifically. I don't think that makes any difference, but she was. And for her, she, of course, only worked during term time. Now, the court confirmed that prorating a holiday entitlement is no longer the lawful way to calculate holiday pay for those employed on a part-year contract, such as, for example, a teacher. Now, as was standard practice for many employers with irregular or zero-hour contracts, Harper calculated her entitlement on a pro rata basis. That worked out at 12.07% of every hour worked. And this was the approach that had been endorsed for a significant period of time by ACAS. And it reflected what we all know as the conformity principle. Now, Ms. Brazel argued that her holiday entitlement should instead be calculated based on her average weekly pay, excluding the weeks she had not worked. But this assertion was entirely dismissed by the court, and they made clear that Ms. Brazel and any other part-year workers are entitled to 5.6 weeks holiday pay, notwithstanding the fact they do not work all year round. And the court expressed the view that the conformity principle is in fact contrary to the interpretation and definition of the Working Time Regulations 1998. The Supreme Court indicated that whilst it may be unlawful for a part-year worker to be treated less favourably, it was in fact not unlawful for those working part-time to be treated more favourably than their full-time counterparts. Another key case that certainly was very popular in the media and the press around the UK during 2022 was the case of Finn and British Bung Manufacturing Company Limited 2022. Now, in this case, the claimant brought several claims in the Employment Tribunal, including a claim for harassment on the grounds of sex under the Equality Act, for having been described as bald with the expletive. And of course, I'm not going to make reference to what the expletive was. Now, the Employment Tribunal ruled that a colleague referring to the claimant as a bald expletive, but the emphasis being on the issue of bald, was conduct that was unwanted and which had, as we all know from the definition of the Act, the purpose of violating the claimant's dignity and creating an intimidating, hostile, degrading, humiliating, or offensive environment for the claimant, such as to satisfy what we all know as the definition of harassment under the Equality Act of 2010. Interestingly, the Employment Tribunal analysed the precise words used together with the context in which those were said. And they found that there was a connection that relates to the word bald to the protected characteristic of sex. Now, whilst the respondent argued women can also be bald, and of course, Mr. Finn was a male and defined himself as a male, the Employment Tribunal stated that baldness is much more prevalent in men than women, and therefore the person on the receiving end of such a remark would be male. So interestingly, we now have the definition of bald falling under the ability for someone to claim under the Equality Act of having the definition of harassment, as we can see on this previous slide, applying to him. What would be interesting is, of course, if a female who suffered from, for example, female pattern baldness or alopecia and female pattern baldness could be defined as, of course, being a disability, and it could be used, but whether it's defined as a protected characteristic of sex towards a female, and whether we would see a different response from the tribunal if a woman was running exactly the same argument. Brexit. We still, unfortunately, cannot forget and ignore the fact that we still have the topic of Brexit hovering over our heads as of 2022 going into 2023. But of course, a review of 2022 looking into 2023 could not refer to it. Now, retained EU law, Revocation and Reform Bill 2022 to 2023 was introduced to the House of Commons, and it has proposed to abolish retained EU law from UK legislation, which of course would include EU elements, on the 31st of December 2023, unless it has been otherwise. So it's something that we need to bear in mind over the next 12 months, that the different elements, for example, working time regulation, it's an EU regulation that has been incorporated into UK legislation, but in terms of the EU significance, it will no longer be relevant. Now, we've covered the issue, of course, of holiday pay. We've covered the issue of those that are self-employed with holiday pay and also part-year workers, but we need to also, of course, not forget 0 hours contracts. Now, the exclusivity terms for 0 hours contracts, unenforceability and redress regulations 2022, not a very catchy title for a regulation, but it's the one we're stuck with, came into force very recently on the 5th of December 2022. And the regulations, interestingly, which is a massive shift, make it automatically unfair to dismiss an employee from day one. So, of course, this is a huge change from what we've seen in the past, whereby individuals could not claim from day one, if the reason or principal reason for the dismissal is they breach an exclusivity term. Exclusivity terms, which is the key element, are defined as any contractual term which prohibits a worker from doing work or performing services under another contract arrangement, or which prohibits a worker from doing so without the employer's consent. From 0 hour contracts to flexible working. Now, there's been a lot of campaigns that have been occurring over not just the past 12 months, but also the past couple of years about how flexible working should be more prevalent and dominant in the lives of employees around the country. Of course, this has been particularly key for individuals who have families, young families, and are seeking to have the ability to work more flexibly. Now, of course, in the past, it's been very much up to the individual employer as to how they view the policy of flexible working, and different employers have demonstrated flexible working as being a key benefit that that individual employer provides, rather than it being something that is required by all employees as a whole. So it's been seen as more of a carrot, but a carrot that only some have chosen to have. And during the past, certainly 12 months, there have been a lot of campaigns that have been done by young mums, not so young mums, in order to try and really allow for a greater flexibility in the modern world that we live in for those that do have families and that are needing to work around those families. Now, employees will be given the right to ask for flexible working from their first day at a new job, as opposed to waiting for 26 weeks. Now, of course, that's a huge change from what we saw in the past, where it was a 26-week requirement. And particularly in a world whereby we have had individuals working from home and during the lockdowns, and we're able to create that level of flexibility subjectively. Now we can have employees correctly and rightly being able to go to their employer and say that they're wanting to seek flexible working from the beginning. There will be a requirement now for employers to consult with their employees as a means of exploring the available options before rejecting the flexible working request. Employees will be given the right to make 2 flexible working requests in any 12-month period. Employees will have to respond to their request within 2 months as opposed to what used to be 3 months. Now, in terms of it being incorporated into a statutory requirement, that is to be seen and seems to be a little bit hazy. And having actually done some analysis of this issue, it does seem as if the government is not ready yet to put pen to paper. And of course, that also fits with what I'll come to in a moment, which is the employment bill, which we still haven't seen. But what is important to remember is that flexible working in 2023 may simply be a more popular request than we've seen before. And employers should be very much aware of the need to assess and analyse that issue for each individual employee when requested. Employment bill. Now, again, the employment bill was notably absent from the Queen's speech in May 2022. And as we're all aware, of course, the Queen's speech sets the legislative agenda for the year ahead. And there's no indication that the King's speech, which will be occurring in 2023, will include the employment bill. But what we have seen is we've seen different private members' bills coming through that actually were initially thought to form part of the employment bill, and therefore they'll seem to be separate bills rather than one whole bill that is currently being introduced. One key private members' bill is the private members' neonatal care leave and pay bill, which was introduced, and if it's passed, would cover at least some aspect of the employment bill that we were expecting to see. And I'm going to come into more detail in that in a moment. A similar private members bill has been introduced, which deals with tips provided by customers. So those, for example, that work in the hospitality industry, bar staff, waitressing, restaurant staff, who will be able to have some form of confidence as to how their tips are dealt with, which of course is not clear on the current legislation. And the government has indicated that it intends to support both private members' bill, which will be seen to come into force, hopefully, at some point down the line in 2023. Now, no changes, which has been campaigned for, will be made to the Equality Act in respect of menopause, which at the moment, there are no plans to introduce menopause as a protected characteristic. Now, over the course of 2022, there have been some significant campaigns. A lot of those campaigns have used the social media and the media to push it, but unfortunately, as of January 2023, it doesn't look as if those changes are being taken up by the government. Now, as I mentioned before about the neonatal care leave and pay bill, on the 15th of July 2022, it passed its second reading in Parliament after receiving government support. And the legislative reforms will allow parents whose babies are receiving specialist care after birth to take up to 12 weeks of paid shared leave, and therefore reduces the pressure on those parents to return to work. Now, if the bill is passed, the right to neonatal care leave will be available to those parents whose babies are admitted to hospital up to the age of 28 days and who have a continuous stay in hospital of 7 full days. So as you can see, there are some very specific requirements that are being included in relation to this neonatal care bill. The right would be available to employees from the first day in a job. Of course, this is the third example of a shift and change to allow for employees to get that requirement on day one, rather than having to wait so many weeks for the entitlement to come into effect. However, the additional neonatal care pay will only be offered to parents who have at least 26 weeks continuous employment and who meet specified earning requirements. So we're seeing there's a little bit of a caveat here. We're giving it to day one for an employee, but the additional pay that they receive will only be entitled to those who have had at least 26 continuous employment. 26 weeks continuous employment period. Employers will be entitled to recover these payments from the government, and it's anticipated that the bill will be passed during 2023. In June 2022, the government published a draft Bill of Rights, which is intended to replace the Human Rights Act of 1998, and it will make fundamental changes to the human rights framework in the UK. Now, what we need to remember, we need to look at over the course of 2023, is how the Bill of Rights is going to have an impact upon both employers and employees. The proposed changes will affect how human rights are enforced, including a permission stage for claimants to demonstrate they have suffered significant disadvantage, and the renewed emphasis on the importance of freedom of expression. So what's going to be interesting to see is if the Bill of Rights actually becomes the Bill of Rights in the form of a act, then whether we see either more or fewer human rights claims being brought through the Employment Tribunal in relation to breaches of the, as at the moment, proposed draft Bill of Rights, which will allow for individuals to bring human rights claims to the Employment Tribunal. So thank you ever so much for attending today's webinar. I hope all of you have a happy, healthy and prosperous 2023, and that hopefully at the end of 2023 we see more developments and it's an interesting year for employment for us all. Thank you very much.